us, but I don't think your client is here yet, unless you're with your client.
No, he was going to try to appear by Zoom. I'm a little concerned whether he will be successful, but if not, I told him to call in.
Okay. Then we'll stand by on your case. Mr. Winfrey is an arraignment. I think that we were planning on getting him a copy of the information, if I recall. So why don't we call that case first, and then the jail can have that device freed up. This is Brown County case number 20 CF. State of Wisconsin, Winfrey. And there is a lot of audio interference because I think the microphone is right there hanging from the wire, Mr. Winfrey. So, yeah, if you just keep that from rubbing on anything, that would reduce the background noise.
Can you hear me?
Yes, we can hear you, yes. The state is here by Assistant District Attorney Kevin Green. Mr. Winfrey is appearing pro se by video conference from the Brown County Jail. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. We are here for an arraignment. I believe at the last court hearing, which was just last week, Mr. Winfrey needed a copy of the information. Have you received a copy of the information now, Mr. Winfrey?
Your Honor, there was a third amended criminal complaint that was filed on December 9th, 2020. I have not received a copy of that amended criminal complaint, and I did want to make an objection to the information being filed before the preliminary examination and before the de novo review decision or judgment or ruling that proceeded after the preliminary hearing.
Yeah.
I can't hear anything.
I'm looking through the courts file right now to look for dates on items.
I wanted to get a look at the third amended criminal complaint before anything further.
Does the state know the date of the preliminary hearing? There's so many things in the courts file that it's hard to determine when the preliminary hearing was.
The preliminary hearing was on.
No, I'm asking the prosecutor. I'm asking the prosecutor.
The preliminary hearing was 11/19/2020, according to our notes. There was first an argument on that date about the sufficiency of the complaint, then the profile and respondent was bind over. I believe the information was filed the same day.
Okay, and I do see that in the file now, that the information was filed after the preliminary hearing bind over decision was made. So the information was properly filed. There's now the third amended criminal complaint was filed December 9th, 2020. ADA Green. Does that appear to be the same charges that are in the information or different charges? Are you able to tell?
I would need one moment to take a look at them.
That, I guess the question would be if an amended information was necessary.
One moment, Your Honor, I'll have to make sure I'm making a proper comparison.
And if I do recall this now, I think it's just paragraph 5 that one of the previous criminal complaint asserted that there were 4 prior convictions for operating while intoxicated, and then this third amended criminal complaint changes that language in paragraph 5 from 3 prior convictions for operating while intoxicated and a conviction based on implied consent for 4 prior countable convictions.
And looking at the 2, I believe that is the only change that I am able to view quickly.
And then at the last hearing, I did make a ruling on the de novo review of Mr. Winfrey and found that the bind over decision was proper and sufficiently supported by what was presented at the preliminary hearing. So we are past that issue also. So we are at the point of an arraignment. So have you received a copy of the information? And the information only outlines the charges. It does not have a probable cause section with the facts. You received that document?
Yes, I have, sir.
Okay. Do you have a right to have me read the entire document, read the charges to you? Do you want me to do that out loud, or do you want to waive reading of that document? I would literally just read the document out loud on the record to you.
Would reading the document prevent it from being amended any further?
Either way, it wouldn't have any impact on the state's ability to do that.
All right, then I waive the reading, sir.
Okay, I'll accept the waiver of the reading of the information. And then would you like to enter a not guilty plea at this point?
I would still like to object to the subject matter jurisdiction of the court and object to the sufficiency of the preliminary examination. I also wanted to object to the judgment raising the defendant's bond to $25,000. I don't believe that there was a motion or a request to review the bond. Specifically, there was only a motion or a request to review the motion to dismiss and the bind over. And I believe that the judgment on the bond was raised unnecessarily.
Okay, well, I have made a decision on the reviewing the preliminary hearing de novo, and that I already made a decision on that at the last hearing. And then I made a very significant record on the reasons why I increased the bond. So we're at the point where you need to enter a plea on the case. Did you want to enter a not guilty plea?
Yeah, I just wanted to voice my objections, and yes, I'll make the non-guilty plea.
Okay, I'm going to enter the not guilty plea into the record on each count. And then there's 2 options at this point. We can set it for a status conference if you're considering filing more motions, or we can just set the case for trial right now.
I will be filing more motions, sir.
I'm looking at the calendar right now for scheduling. I'm still looking at the court's calendar. We will call the case Friday, February 19th at 10 o'clock. And Mr. Winfrey, I would expect any motions that you wanted to file to be filed by then. That would not be the motion hearing, but we would we would talk about the sufficiency of the motions that you file. And if an evidentiary hearing is necessary on the motions, then we would schedule it on that day. Understood?
I understand, sir.
Friday, February 19th at 10 o'clock. Anything additional from the state?
Not for today, Your Honor. Thank you.
But I would warn you, Mr. Winfrey, as far as the sufficiency of the preliminary hearing and the charges go, I've already made a ruling on that. So anything further on that issue would have to be taken up with the Court of Appeals. Understood?
I just wanted my objection to be noted on the record, sir. And
Yes, you've definitely sufficiently done that. Yes.
okay, that's all then. Thank you.
Anything additional from the state?
Not for today. Thank you.
Then bond continues, and that's all for today. Thank you.
Sir.
Yes, Mr. Winfrey.
Can you, I still need a copy of that third amended criminal complaint. If you can have the state get that to me. I have no idea what the probable cause amended, what was going on with that. I'd like to see that. That's constitutional right to know that.
When we fax the minute sheet for this hearing to the jail, we're going to fax the copy of the document as well.
I'd appreciate that, sir. Thank you.
Yep. Yeah, my staff is also reminding me that we didn't do the waiver of the in-person appearance for the arraignment. You do it for the arraignment where we just entered the not guilty plea. You do have a right to be present in person in the courtroom for that hearing. Are you willing to waive your right to be present so that we could accomplish it today?
That's already happened today you're talking about?
Correct, yeah.
That's fine, sir. I'm already not there.
Okay. So I'll continue the not guilty plea that I entered into the record. That's all we would have been doing. That's all an arraignment is entering the plea into the record. And then bond continues. That's all for today. Thank you.
Thank you.
Attorney Klaus, do we have your client, Anthony Socha?
He's the 619-2132,
Okay. What are we doing on your case today?
plea and sentencing.
Okay. Michael DeKaiser. Attorney Crosby, have you had contact with him recently?
I have not spoken to him recently, Judge.
Okay, well, let's call that case. This is Brown County case number 21 CM10. Wisconsin with Michael Shane DeKaiser. The state is here by Assistant District Attorney Kevin Green. Attorney Michael Crosby is here. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Mr. DeKaiser does not appear by the video conference or in the courtroom. There's also a Brown County Criminal Justice Services notice that was sent to the court that he is not in compliance. Attorney Crosby, have you had any recent contact with your client?
Not recent, Your Honor.
ADA Green, any comment from the state?
I believe the defendant was present by Zoom when this was calendared. I am going to ask for a bench warrant.
Based on the non-appearance and the Criminal Justice Services violation, I am going to issue the bench warrant forthwith. It can be quashed in Court Commissioner Room A if you're able to get a hold of him, Attorney Crosby.
Thank you, Judge.
And then that's all for today on that case. And then let's call the Melchert case before we get to our plea and sentencing cases. This is 20 CT 178, 20 CT 214, State of Wisconsin versus Jonathan Leroy Melchert. Can you hear us, Mr. Melchert?
Yes, I can, Your Honor.
The state is here by Assistant District Attorney Kevin Green. Mr. Melchert is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. These two cases are driver's license violations. They are traffic offenses, but they are criminal misdemeanor cases. Mr. Melchert, were you, I believe this was scheduled, you were considering getting a lawyer, was that correct? Mr. Melchert?
I apparently am still making too much with my job that I'm working.
Okay. Did you want to?
I know for a fact.
ADA Green, do you know what the offer is on the case? Has that been provided to Mr. Melchert?
I don't believe there has been an offer sent to Mr. Melchert, in part because I think we are expecting counsel.
Okay.
And I do not have one to provide today.
Mr. Melchert, then you'd either need to hire a lawyer at your own expense, or you can represent yourself. If either way, you'd be reaching out to the DA's office to see what their offer is on the case and to discuss a potential resolution. If the parties can't come to a resolution, then the case would be scheduled for a trial. Did you want to continue to look for a lawyer, or did you want to represent yourself?
I was actually supposed to do that today too. I had a couple things I had to fill out to get in touch with one, so I was going to do that later on today.
Okay. Well, why don't I give you some more time to accomplish that task then? Why don't we schedule this for Tuesday, March 9th at 2 o'clock? Tuesday, March 9th at 2 o'clock. Did you get that time, Mr. Melchert?
Yes, I did.
Anything additional from the state?
No, Your Honor, thank you.
And bond continues, and that's all for today on Mr. Melchert's case. Thank you. And then Attorney Schenk will take your case next, and then Attorney Klaus's. Although Attorney Klaus, before we do that, I know your client's only appearing by phone, and I'd normally require appearance by video conference. And it's an OWI sentencing that's going to have a mandatory minimum jail sentence. Does your client have video capability, Attorney Klaus?
My understanding is he tried to make that happen this morning and couldn't, and so then phoned in.
Okay. Why don't I think then I'm going to schedule your case for an in-person hearing then. Do a clean sentencing, because me being able to visually see him, I think, is an important part of a sentencing. So why don't we call Mr. Socha's case? This is 20 CT 726, State of Wisconsin versus Anthony Frank Socha Jr. The state is here by Assistant District Attorney Kevin Green. Attorney Dan Klaus is here. Mr. Socha is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. Attorney Klaus submitted a plea questionnaire form indicating that the case is resolved. However, Mr. Socha is appearing by phone, and it sounds like he attempted to appear by video, but he was unable to connect, so he called in by phone. Mr. Socha, are you able to, I had to mute your device because there was some background noise. Are you able to unmute it? Sometimes *6 will act as a mute button for you to unmute it. Mr. Socha, if you're able to unmute your device. Sometimes *6 will act as a mute button. *6. Okay, it looks like you were able to accomplish that. Can you hear us, Mr. Socha?
Yes.
Okay. Do you have access to a device with video capability on it?
Yes, I tried doing it on my phone and it wouldn't go through and it wouldn't bring up the site or anything.
Okay. Do you think it was because of the wireless connection or the device? Any thoughts?
It might have been from the wireless connection.
Okay. Attorney Klaus, do we want to schedule this again for a video conference hearing or just schedule it for an in-person hearing? What do you think?
Anthony, would you rather be in the courtroom when we did this, or would you want to come to my office and do this? It doesn't matter to me.
I can go to your office if that's easier for everybody.
Yeah, why don't we schedule this for video and I'll have him appear with me in my office.
Okay, that sounds like a good plan. How about Friday, February 26th at 10:30?
That's fine.
Friday, February 26th at 10:30. Did you get that date, Mr. Socha?
Yes. Yes, sir.
And anything additional from the state?
Not for today, Your Honor. Thank you.
One thing from us, Judge, I believe my client has a new address.
Okay, why don't you say it right now?
W2643 Center Road in Bondwell. And the zip is 54107.
Okay, got it. Anything else for today's purpose?
No, thank you.
Then bond continues, and that's all for today. Thank you. Then we'll call Attorney Schenk's case. This is Brown County case number 19 CM 1525, State of Wisconsin versus James Jonathan Anderson. The state is here by Assistant District Attorney Kevin Green. Attorney Aaron Schenk is here. His client, Mr. Anderson, is appearing by video. We're doing the hearing by video and video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Schenk did submit a plea questionnaire and waiver of rights form. It looks like the expected plan is a no contest plea to operating while intoxicated, second offense. Is that correct, Attorney Schenk?
Yes, and after that particular plea questionnaire that I filed another one because it didn't have the count of disorderly conduct on there. So there is another plea questionnaire that I filed that's correct, that has both counts that my client is pleading to.
Okay. And then I assume count 3 is being dismissed?
Yes, Your Honor. The state would so move at this time.
Okay. You see it in there? Mr. Anderson, is it your intent to plead no contest to disorderly conduct, operating while intoxicated, second offense?
Yes.
The new plea form we don't see in the court's queue for processing documents. Do you know when you submitted it?
I did. I'll give you the number in just a second here. Let me pull up my filing queue. Just a moment here, Your Honor. I'm looking at my e-filing queue, and it shows that only the original plea questionnaire was filed. I seem to remember that there may have been a rejection of the second. I'm going to try to verify that here.
Okay.
Either way, I will have to refile it. Well, nonetheless, Your Honor, I'm looking to see, it shows that there was a rejected amended plea questionnaire and waiver of rights form back on November 20th, and it didn't give me a reason why. But either way, I'm going to have to refile it. Does the court want me to do that before we move forward, or?
We can go forward on it. I have the elements for the offense.
Okay.
We can continue with it today.
Okay.
Just file the document when you're able to.
Sure.
Did you talk to your client about the video conference appearance?
I did. We had a discussion about his right to be in person for this plea and sentencing hearing, and the situation regarding the pandemic, how that's affecting in-person appearances. And my client would be waiving his right to appear personally.
Is that correct, Mr. Anderson?
Yes.
Okay, so you're okay with the video conference appearance, and you're going to waive your right to an in-person appearance?
Correct.
If it becomes necessary to meet with your lawyer privately, we can accommodate that with this video conference appearance. And then Attorney Schenk, did you review the plea form in person with your client or a different way?
I reviewed the plea form with the client over the phone. He'll contact me.
And then did you review the jury instructions with your client?
I did. We went through all of the elements of both offenses.
Okay, great. So Mr. Anderson, if you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that?
Yes.
According to the plea form, you are 43 years old. Is that correct?
Yes.
And you do have a high school diploma, correct?
Yes.
And you do understand English, correct?
Yes.
According to the plea form, you are not currently receiving treatment for mental illness or disorder. Is that correct?
Correct.
And you have not had any alcohol, medications, or other drugs in the last 24 hours. Is that correct?
Correct.
The charge in count 1 is misdemeanor disorderly conduct. That is a Class B misdemeanor. The maximum penalty is 90 days jail or a $1,000 fine or both. Do you understand that's the maximum penalty for count 1?
Yes.
And then as to count 2, the charge is misdemeanor operating a motor vehicle while under the influence, second offense. The maximum penalty is 6 months jail or a $1,100 fine or both. Do you understand that's the maximum penalty?
Yes.
There is a minimum penalty also of 5 days jail and a $350 fine. Do you understand that's the minimum penalty?
Yes.
There will also be a driver's license revocation between 1 year and 18 months, and the ignition interlock device will be required as well. Do you understand that?
Yes.
The elements for count 1 disorderly conduct are first, that you engaged in violent, abusive, indecent, profane, boisterous, unreasonably loud, or otherwise disorderly conduct. And second, that your conduct under the circumstances tended to cause or provoke a disturbance. You understand those are the elements of disorderly conduct?
Yes.
As to count 2, operating a motor vehicle while under the influence, the first element is that you operated a motor vehicle on a highway. Second, that at the time of the operation, you were under the influence of an intoxicant. Do you understand those are the elements of that offense?
Yes.
And the state is asserting that you have 1 prior conviction. The date of that conviction is June 5th, 2014, with an offense date on December 1st, 2013. Do you agree that that is 1 prior conviction for operating while intoxicated?
Yes.
And you understand that that's what makes this a second offense?
Yes.
you understand that I can sentence you up to the maximum penalties? Do you understand?
Yes.
And I don't have to go along with any plea agreement or recommendation. Do you understand?
Yes, I do.
The criminal complaint includes the facts that the state believes are true. Do you agree there are enough facts in that criminal complaint to support your plea for disorderly conduct and operating while intoxicated, second offense?
I do.
You have the following constitutional rights: the right to a jury trial where all 12 jurors would have to agree that you're either guilty or not guilty, your right to remain silent, your right to testify and present evidence, your right to use subpoenas to require witnesses to come to court, your right to confront and cross-examine witnesses who testify, and your right to make the state prove that you're guilty beyond a reasonable doubt. You understand that you'd be giving up those rights by entering a no contest plea?
I do.
You understand that if I accept your no contest plea, I will find you guilty of the offenses?
I understand.
Are you doing this of your own free will?
Yes.
Has anybody put any pressure on you or forced you to make a plea?
No.
Do you have any questions about anything that we've talked about so far?
No.
Have you been able to see me and hear me clearly throughout the hearing so far?
I have.
And I've been able to see you and hear you clearly as well. Have you had sufficient time to review this plea form with your lawyer?
I have.
And did you sign the document yourself?
I think so. I did it through the computer.
Okay, but that is your, it does look like it's probably through a computer. That does seem consistent, but that is your mark
Yes.
using the computer on the form?
Yes.
Does that verify you reviewed the entire form with your lawyer over the phone?
It does.
Attorney Schenk, are you satisfied that your client is freely, voluntarily, intelligently, and knowingly making this plea?
Yes, Your Honor.
Are you satisfied he understands the elements, the facts, and the rights he is giving up?
Yes.
Then Mr. Anderson, to the charge in count 1, misdemeanor disorderly conduct, what is your plea?
Guilty.
The plea form says no contest.
Yeah. Sorry, no contest.
Okay, and Attorney Schenk, you agree your client's intending to plead no contest?
Yes.
Okay. So I'll say it again, Mr. Anderson. As to count 1, misdemeanor disorderly conduct, what is your plea?
No contest.
As to count 2, misdemeanor operating a motor vehicle while under the influence, what is your second offense? What is your plea?
No contest.
I will accept the no contest pleas. I'll find that they've been freely, voluntarily, intelligently, and knowingly made. I'll find he understands the elements of the crimes. We reviewed those today. He understands the facts from the criminal complaint. He understands the rights that he is giving up, which we reviewed today. I will find him guilty of the 2 offenses and order a judgment of conviction entered into the record. Count 3, the PAC count, will be dismissed. And what is the state's recommendation?
Your Honor, I first need to inquire from Attorney Schenk because there was an option on count 2. Mr. Schenk, are you joining or is this an argued on count 2?
Let me pull up the offer again. Give me just a second.
And while we're waiting for Attorney Schenk, this is the last case at 10 o'clock. And then there are 2 cases at 10:30 that will follow right after this case.
Mr. Green, I'm looking at my offer from Ms. Hillman. I don't see an option anywhere. Maybe fill me in.
I apologize. The option I have is on just, on count 1, it's 10 days either way. On count 2, either the state will argue for the right side guidelines for the 0.258, or the defense can join and we recommend the left side. The
Oh,
difference
okay.
is
Patient for the left side.
you join for the left side.
Yes.
Okay, Your Honor, then the state's going to recommend on count 1, 10 days Brown County Jail. The bad behavior, but the duration of that bad behavior, in essence, continued throughout the stop and all the way through the hospital. I do think under those circumstances, putting the officers through that is just unacceptable. On count 2, we are going to recommend the left side guidelines for the 0.258 blood alcohol. That's 80 days Brown County Jail consecutive. A $750 fine plus costs, total is $1,933. 17-month revocation of driver's license, 17 months ignition interlock device, ODA assessment and follow-through treatment, and the blood draw fee of $46.50. Excuse me. Obviously, this is a second offense. It is serious. The driving here is of some concern. What is of a greater concern is the blood alcohol. 0.258 is quite intoxicated. That's a relatively high BAC compared to what we see. I do think the guidelines are appropriate in this case. There was no accident. I don't think there's a reason really to deviate either way at this point. I think he's accepting responsibility. He's joining on the guidelines. I do think they're appropriate here. But we do believe that the 10 days in the disorderly conduct is also appropriate. Thank you.
Attorney Shank?
Thank you, Your Honor. When I talked to my client about the events of this particular evening, I was kind of surprised by them because Mr. Anderson does not come across as somebody that would conduct himself the way that he did on this particular evening. Starting with the driving, although the driving is concerning, I can indicate because my office is kind of right there by where this whole incident happened. Switching from the regular lanes to the turn lanes on Military and Mason is a mistake that I see people almost make daily because of the big shift you have to make from one side to the other. But nonetheless, I mean, when my client finally was pulled over, the blood alcohol level ended up being what it was. It was very, very high. My client understands that. He appreciates that there is a joint recommendation here for the left-sided guidelines. But back to my point about how it was very out of character, my client was very, very embarrassed reading about the way that he had conducted himself that evening. I think it's not uncommon to have people that don't quite remember or want to remember how they acted on those particular evenings. But I hope you hear it when my client has his chance to speak with you. It just doesn't sound like the kind of person that would do that. And to his credit, he's taken some steps to better himself afterwards. He hasn't touched a drop of alcohol since this whole incident happened. He's ahead of the game on trying to get enrolled for his AODA. That's a lot harder to do these days because of the pandemic. My client also understands that this being his second offense, and although his last offense was about 7 years ago, that still shows that there may be an issue here. So he's interested in exploring that. The only thing that we're going to be doing, Your Honor, in terms of a different look at the sentence is to make the 10 days in jail concurrent to his OWI sentence. Obviously, he feels awful about what happened in regards to the way he talked and acted with the police officers that particular evening. But I think kind of the amount of time that has gone by, the steps that he's taken, perhaps might mitigate that a little bit. So I'd ask for the 10 days to be concurrent. Other than that, like I said, my client's going to have a chance to speak with you here. He may or may not choose to say anything. He's not the most well-versed public speaker that we've ever known, but hopefully you can hear the sincerity in what he does say. Thank you.
Does he have a employment history?
Yes.
Okay. Attorney Shank, do you want him to address employment history or?
Yeah, I think that'd be a good idea.
Okay. Well, Mr. Anderson, what's your employment history?
How far back do you want me to go?
Let's say 5 years.
I've been at the same place for 8.
Okay. And where is that?
It's Bay Valley Foods in Hobart, the distribution center.
Okay. And now is the opportunity to address the court before I issue a sentence if you choose to do so.
Yeah, my attorney's correct. I am horribly embarrassed. I always never drive when I've been drinking, and what happened, I just went home and went to bed. And when I woke up, I got a phone call and I didn't realize I was still that inebriated. And I did something very, very stupid. And what can I say? I should not have acted that way. About a year ago, I put the interlock thing in my car. I don't drive at all, but I did it just for safety concerns. But like you said, I haven't touched a drop of alcohol since this happened. But can I say I apologize? That's really all I can do.
Thank you. When the court issues a sentence, I have to consider the protection of the public, the gravity of the offense, the rehabilitative needs of the defendant, character of the defendant, and deterrence of others, then apply the Galleon sentencing factors to those sentencing objectives. In terms of past record of criminal offenses and history of undesirable behavior, the only offense that appears is on Mr. Anderson's record is the prior OWI first in 2014. So it does seem fair to say that this does seem pretty out of character and surprising for Mr. Anderson to have participated in the behavior that he did in this case, driving with a very high BAC of 0.258, and just his entire behavior from the evening demonstrated that he was pretty intoxicated and a danger to the community driving a vehicle. The disorderly conduct, I mean, it was resistful behavior, I guess is a way of describing it, and then vulgar name calling towards the officers, and certainly caused a disturbance in the community, something that Mr. Anderson probably never would have gotten involved in if he weren't intoxicated, but unfortunately he got very intoxicated and participated in this type of behavior. He is accepting responsibility for the offenses by pleading no contest here today. I think he is genuinely remorseful and embarrassed by what took place based on his words here today in court. It sounds like he's trying to get into AODA programming, but that it sounds like it's a little bit of a challenge for him, but he represents that he is abstained from alcohol for a long period of time now. He's a high school graduate with an employment history as well. When I consider all of those positive and negative factors, what I'm going to do on count one is I'm going to do 5 days jail consecutive to count two. I do think that the disorderly behavior was of a significant nature that there should be some consecutive sentence for count one. So, but it'll be 5 days in the Brown County Jail consecutive with court costs on that count. For count two, the left side guidelines, 80 days jail consecutive to count one. That'll be with Huber and good time. $750 fine for a total of $1,933. That has to be paid within 6 months or set up a payment plan with the clerk of court's office. 17 months revocation of driver's license, 17 months of the ignition interlock device. That can be retroactive and concurrent to any administrative suspension. An AODA assessment, follow through with all treatment recommendations. A blood draw fee of $46.50. That has to be paid within 30 days, the $46.50. And then a report date within 60 days.
I'm sorry, what?
Attorney Schenk. For the jail sentence has to commence within 60 days.
Okay.
Attorney Schenk, I think you turned off the camera instead of unmuting. Are you able to hear us, Attorney Schenk?
I'm sorry about that. Every time I pull up my calendar, my camera shuts off, but perhaps Friday, March 26th. James, is that okay?
For what is this for?
Reporting for your
Oh, yeah. Yeah. Friday, what?
March 26th.
Yes.
Okay, that will work. Anything additional from the state?
Your Honor, it appears there may be credit, at least is there a day or two credit, I think?
I don't believe there is. I checked the official jail records this morning and also the criminal complaint. It kind of shows that he was booked and released fairly soon after he was brought in.
Okay. Then I have nothing further, Your Honor.
The only other thing that I have, Your Honor, and I really don't know the answer to this. I was trying to find an answer because I've never run into this, but my client had indicated that he has had an ignition interlock device in his vehicle for a long time now. I'm not sure that it can be retroactive as far as that order goes back to when he put it in. I've actually never had a client do that before. So if the court has the power to do that, I would ask for that.
Any objection from the state?
Your Honor, I simply don't know, like counsel, I've not seen that before. I don't know if that's even legally possible.
Okay, I'll note it on the minute sheet that the IID requirement can be retroactive and concurrent if that applies.
Okay.
No credit. And then if you could review the post-conviction rights with your client, and then that's all for today on this case. Thank you.
Thank you.
Excuse me, real quick. What? 1 second. Hello.
Did you have a question, Mr. Anderson?
Yeah. Is it possible to get an exemption? I have a motorcycle that's in pieces. It hasn't been started in years, but I know that it could be a problem.
Okay.
I'd have to get a second interlock.
There is a standard form that you have to submit to the court. Motorcycles are pretty standard for getting an exemption because you can't put the device on the motorcycle anyway.
Okay.
Okay, but there is a standard form you do have to submit.
Okay. All right, thank you. That's it.
My staff says you have to actually come down to the courthouse to get the form.
Okay.
Okay.
And that $46.50, do I pay that to you or do I pay it to the blood draw people?
The Brown County Clerk of Court's office.
Okay, so it's all in one. To pay my fine, I can just do it all in one shot?
Yes.
Okay, thank you.
Anything else, Attorney Schenk?
No, thank you.
Okay, then that's all for today. Thank you. Attorney Adolph, what are we planning on doing on your case?
Plea and sentencing, Your Honor.
Okay. And then it looks like Ms. Furtado does not have a lawyer. Was there anything submitted on that case? Does not look like it. Ms. Frida Furtado, I did mute your device because there's background noise. Are you able to unmute it?
Yeah.
Okay, and start the video. Okay, now I can see you. There's been nothing submitted on that file, so why don't we call that one real quick before we do the plea and sentencing. This is 20 CM 481, State of Wisconsin versus Frida Araceli Furtado. We're doing the hearing by video conference because of a global, national and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There's no one in the courtroom gallery. Assistant District Attorney Kevin Green is here. Ms. Furtado is here. Has the DA's office had any contact with
Your Honor,
Furtado?
not specifically, but I believe we had sent an offer. At the last hearing, the defendant indicated she wished to accept the offer and intended to proceed pro se.
Okay.
I believe the note also said a plea form was going to be mailed and the defendant would have to get that back to the court.
Okay.
That was the notes from the last hearing.
We did mail the forms to you, Ms. Furtado on December 2nd. Did you ever receive the forms?
Yeah, I've been busy with this job that I recently quit because due to my pregnancy and I do got the $100. I was planning on if I could turn that in today or Monday.
But it's more complicated than that because this is an actual criminal charge. So I have to make sure that you know all of your rights before you enter a plea to it. When is your due date?
June 17.
Okay, so it's not till June. I think I'm going to require you to come down to the courthouse. I think that would just be easiest for everybody to do a plea and sentencing hearing. Are you comfortable with that?
Yeah, I got a quick question. I had did a mistake on the paper. I don't know if I could like get another sheet.
Okay, well, when you come down to the courthouse for the hearing, there'll be more forms there'll be blank forms for you to fill out here.
Okay.
So I think that'd be easiest if you came down to the courthouse. How about Friday, March 26th at 4 o'clock?
Okay.
Friday, March 26th at 4 o'clock. Anything additional from the state?
No, Your Honor, not for today.
There is a public health screening to get into the courthouse downtown, and you do have to wear a mask when you're inside the building, okay?
Okay.
The bond continues, and that's all for today. Thank you. And then we have Brown County case number 20 CM 644, State of Wisconsin versus Jordan J. Hahn. The state is here by Assistant District Attorney Kevin Green. Attorney Tara Adolph is here. Mr. Hahn is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom. For everybody's health and safety, we are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Adolph has submitted a plea questionnaire and waiver of rights form, and it looks like the intended plan is to plead no contest to 2 counts of misdemeanor retail theft. Is that correct, Attorney Adolph?
That is accurate, Your Honor.
Do you know which 2 counts they would be out of the 3?
Count 2 and count 3.
Okay. Is that the state's understanding?
It is, Your Honor.
And then what would happen to count 1?
Count 1, I believe, is dismissed.
It skipped second there when you were saying dismissed, I think.
I'm sorry, dismissed but read in, please.
Okay. Is that your understanding, Attorney Adolph?
It is.
And Mr. Hahn, is that your understanding?
Yes, Your Honor.
Okay. Am I saying your last name correctly?
Yep, Han.
And ADA Green is the state in compliance with victim notification.
I believe we are, Your Honor.
Attorney Adolph, how did you read the plea form with your client? Was it in person or some other way?
I believe we reviewed it over the phone. Sorry, that was a while ago, but I do believe we reviewed it over the phone.
Okay. And you reviewed the jury instruction with your client as well?
I did.
Mr. Hahn, do you need any additional time to review the plea form with your lawyer?
No, I don't, Your Honor.
Do you need any additional time to review the criminal complaint with your lawyer?
I do not, Your Honor.
And you intend to plead no contest to count 2 and count 3, which are both misdemeanor retail theft, is that correct?
Yes.
But actually, before we get into the plea, the last thing is the video appearance. Did you talk to your client about that, Attorney Adolph?
I did, Your Honor. It is my understanding he is willing to waive an in-person hearing video conferencing.
Mr. Hahn, you do have a right to be present in person. For a plea and sentencing, are you willing to waive your right to be present in person so that we can continue with the video conference?
Yes, Your Honor.
If it becomes necessary to speak with your lawyer privately at some point, we can accommodate that with the video conference appearance. The required warning I have to give you is that if you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law. Do you understand that?
Yes, I do.
According to the plea form, you are 26 years old. Is that correct?
Yes, Your Honor.
And you do have a high school diploma?
Yes.
And you do understand English, correct?
Yes.
According to the plea form, you are not currently receiving treatment for mental illness or disorder. Is that correct?
That is correct.
And you have not had any alcohol, medications, or other drugs in the last 24 hours. Is that correct?
That is correct.
Have you been able to see me and hear me clearly so far?
Yes, I have.
And I'm able to see you and hear you clearly as well. Count 2 is misdemeanor retail theft. The maximum penalty is 9 months jail or a $10,000 fine or both. Do you understand that?
Yes, I do.
And then count 3 is the same charge, misdemeanor retail theft. The maximum penalty is 9 months jail or a $10,000 fine or both. Do you understand that?
Yes, I do.
You understand I don't have to go along with any plea agreement or recommendation, and I could sentence you up to the maximum penalty. Do you understand?
Yes, I do.
And if I placed you on probation and your probation was later revoked and you had to come back to me for sentencing again after revocation, you understand I could sentence you up to the maximum penalty at that time?
Yes, I do.
The elements of this offense are first, that you intentionally took and carried away the property of another. Second, that the property was merchandise held for resale by a merchant. Third, you knew the property was merchandise held for resale by a merchant. Fourth, the merchant did not consent. Fifth, you knew the merchant did not consent. And sixth, you intended to deprive the merchant permanently of possession of the merchandise. You understand those are the elements of misdemeanor retail theft?
I do.
The criminal complaint outlines the facts that the state believes are true. Do you agree that there are enough facts in the criminal complaint to support your plea for each of these retail theft counts?
Yes.
Your constitutional rights are the right to a jury trial where all 12 jurors would have to agree that you're either guilty or not guilty. Your right to remain silent, your right to testify and present evidence, your right to use subpoenas to require witnesses to come to court, your right to confront and cross-examine witnesses who testify in court, and your right to make the state prove that you're guilty beyond a reasonable doubt. You understand you'd be giving up those rights by entering a no contest plea?
Yes, I do, Your Honor.
You understand if I accept your no contest plea, I will find you guilty of the offense?
Yes.
Are you doing this of your own free will?
Yes, I am.
Has anybody put any pressure on you or forced you to make this plea?
No, Your Honor.
You understand that I could require you to pay restitution to a victim in this case?
Yes, Your Honor.
And that includes on a read-in offense, do you understand?
Okay. Yes.
When something is dismissed and read in, I cannot sentence you on that count because it's dismissed. But when it's read in, I can consider the conduct as a whole, do you understand?
I do, Your Honor.
Attorney Adolph, are you satisfied your client is freely, voluntarily, intelligently, and knowingly making this plea?
I am so satisfied, Your Honor.
Are you satisfied he understands the elements, the facts, and the rights he is giving up?
Yes, Your Honor.
Mr. Hahn, are you ready to enter a plea at this time then?
I am, Your Honor.
As to count 2, misdemeanor retail theft, what is your plea?
No contest.
As to count 3, misdemeanor retail theft, what is your plea?
No contest.
I will accept the no contest pleas. I'll find that they've been freely, voluntarily, intelligently, and knowingly made. that he understands the elements, the facts that support the elements, and he understands the rights that he is giving up. I will find Mr. Hahn guilty of each of the 2 counts and order judgment of conviction entered into the record. Count 1 will be dismissed but read in. Is that correct, ADA Green?
Yes, Your Honor.
Then count 1 is dismissed but read in. And then moving to sentencing, what is the state's recommendation?
Your Honor, we're going to recommend 10 days Brown County Jail with Huber and good time. Restitution to target of $517.70 and court costs. Your Honor, in this case, this is a theft by employee case. It's a violation of trust. In general, retail theft adds cost to every consumer that goes into a store to purchase anything. That cost is being passed on to other consumers. The public at large takes some of this burden. But this is, again, more troubling in that it is an employee. Some of the items were food or soft drinks, but it also included an Apple iWatch. I think the restitution is appropriate. I do think the 10 days jail, given that violation of trust, is appropriate as well. Would ask that you impose that sentence.
Attorney Ada.
Thank you, Your Honor. My client is 26 years old and he's employed full-time as a center facilitator for a special needs center. He's been employed there for over a year. He's currently attending college at UWGB and is a high school graduate. He's a practicing Christian and attends Destiny Church in De Pere on a regular basis. He has no prior criminal record. After numerous discussions with my client, Your Honor, what I can tell this court is that he was simply making very poor, immature decisions. The incidents in question occurred over 2 years ago, and at that time, my client was cooperative with officers when they wanted to question him. Since then, he has not been into any trouble, and I think he's grown immensely. We've had a lot of conversations about what he's done and where he's gone. I think he's in a stable, secure relationship. He has positive peers and is showing a good work ethic. He spends his full-time career working with special needs individuals, and I think that speaks highly of his character. And he's been adamant with me that these offenses are a blip on the radar, and really he has learned from what has happened here. Given the aged nature of these offenses, while serious, they're also minor in the grand scheme of things. His current status, we're asking for the court to impose a 6 months withheld probation sentence. It would allow him to address any outstanding issues that have not been addressed in the past 2 years. It would allow him time to pay the restitution. And most importantly, we are asking for expungement, and we believe the probation sentence would allow for the court to see where Mr. Hahn's been at in the next 6 months and show that he's not going to be in any additional trouble. We do not believe this recommendation unduly depreciates the nature of this offense. We do believe it would serve to protect the public and adequately takes into account my client's character, Your Honor. Thank you.
Thank you. ADA Green, is that correct? There's no prior record that you're aware of?
That's correct, no prior record.
And does the state take a position on expungement? I think because of the offense.
No, we will take no position.
Okay, I think even though he's 26 now, I think the offense date, he was under the age of 25, so I think he meets the age requirement. Mr. Hahn. Oh.
I'd say I would agree, Your Honor, that he would still technically be eligible, but I'll take no position.
Okay. Mr. Hahn, do you have any comment you want to make to the court before I issue a sentence?
I do. I just wanted to say I made some dumb and regrettable choices in that time in my life. This whole experience, I've learned from that mistake, and I want to be able to put it behind me for the future. I am deeply sorry for the decision I made in that time of my life. And from this experience, I know for certain that I will not put anybody, myself or any individuals or companies in this position again.
Thank you. When the court issues sentence, I have to consider the protection of the public, the gravity of the offense, the rehabilitative needs of the defendant, character of the defendant, and deterrence of others, then apply the Galleon sentencing factors to those sentencing objectives. I think that deterrence is always a significant sentencing objective in retail theft type situations. The state is right that this is a substantial inconvenience for an employer to have to deal with retail theft. And in this case, there's the violation of trust as being an employee, which the employer has to deal with as well. So there's an added layer to this case. The costs of a retail theft are usually get passed down to the consumer, so it does impact the entire community as a whole when there's retail theft going on in the community. Mr. Hahn does have an employment history. He is trying to improve his educational standing, which are positive factors. He has accepted responsibility for the offenses by pleading no contest to the 2 offenses, and I believe he is genuinely remorseful with his words here today. There's no prior record, so this does seem to be a pretty out of character incident that I don't think anyone would have predicted somebody in Mr. Hahn's situation would have committed. There is a fairly significant amount of restitution that's at issue in this case, $517.70. Because he has no record, I do think that this is a probation case. That the court is to consider probation as the first alternative when issuing a sentence, and if Attorney Adolph is representing that Mr. Hahn would like to do probation, I think that's what the sentence of the court is going to be, and it's actually going to be a withheld sentence. I am going to have it be 12 months though. It's going to be a full year of probation, and that's because I am going to authorize the expungement as well upon successful completion of the sentence. He'll have no contact with any Target store, complete a compass evaluation and follow through with any treatment recommendations, restitution of $517.70 to the Target on Limekiln Road. And pay the court costs during the period of probation as well. Instead of a jail sentence, I am going to require 50 hours of community service as well as a condition of probation. So, Mr. Hahn, do you understand what expungement is?
I do, Your Honor.
Okay. What's your understanding of it?
After I complete the probation and the community service, it will essentially not be on my record.
Yeah, it'll get eliminated from the public record and the court record of it. The DA's office and law enforcement will always have their record available, but you would not, the conviction would be expunged from your record. So that is a pretty substantial benefit that the Wisconsin state legislature has afforded people of your age. So I hope that acts as a very significant incentive to do everything you have to do on probation to be successful, okay?
Thank you, Your Honor.
Do you have any questions about anything?
I do not.
ADA Green, anything additional?
Not for today, Your Honor. Thank you.
And Attorney Adolph, anything else from your perspective?
No, Your Honor. Thank you.
If you could review the post-conviction rights with your client, and then that's all for today. Thank you. And then we'll move to Attorney Schenk's case. This is Brown County case numbers 19 CF 1080, 19 CT 574. State of Wisconsin versus Juan Manuel Solis. The state is here by Assistant District Attorney Kevin Green. Attorney Aaron Schenk is present. Mr. Solis is appearing by video. We're doing the hearing by video conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube for public access. The courthouse is open to the public. There's no one in the courtroom gallery. Attorney Schenk, what is our status here today?
Well, Your Honor, the request I'm about to make may seem a little bit repetitive, but my client is asking for another date when we could come back and enter a plea and possibly go to sentencing. The offer calls for a jail sentence, and if that happens, he's going to have to make arrangements. I had asked for this a couple of times in the past because my client was offered and he accepted a job in Kentucky. He's since been transferred to Texas and is in the same position he was back when he started in Kentucky. So long story short, in the interest of him not losing his job, I'd ask the court to perhaps give us another date to do this, maybe in about 45 to 60 days.
Taking a look at my calendar. What about Friday, March 26th at 2 o'clock?
Friday, March 26th at 2 o'clock should be fine.
And were you anticipating an in-person appearance or still the video conference appearance?
I would request a video conference mainly because of the distance.
Okay. Friday, March 26th at 2 o'clock. So Mr. Solis, I did have to mute your device because there was some background noise. Can you unmute the device just to confirm that you heard the date of Friday, March 26th at 2 o'clock?
Yes, sir.
Okay. And we're doing these hearings by video conference. Normally, we would require you to be in person in the courtroom. So it's really convenient for you to attend court by video. So there's no excuse for you not to attend. Understood?
Yes, sir.
Okay. Anything additional from the state?
No, Your Honor, thank you.
Attorney Schenk, anything else?
No, thank you.
And bond continues, not the court. Thank you.
Thank you.
And I think we have a break here until 11:30.
That appears just one more, I believe, right?
Yep.
Okay.
Well, we don't have defendant or lawyer yet. Are you gonna be back this afternoon, Kevin, or are you, somebody else gonna be here? Mhm. There is somebody calling in, so let's see who that is. Steven Schwarzenberger?
Yes.
Okay, if you can, I'm Judge Lee Joyce. If you can stand by until your case is called. We're waiting for the other parties to sign in still.
Okay.
We have Attorney Zawada now.
Morning, Judge.
Good morning. Mr. Schwarzenberger is on the phone. We had ADA Kevin Green, but then it looked like his screen froze and he dropped off the Zoom feed. So we'll see if he's able to sign back in. But this is the only case at 11:30.
How are you doing, Judge?
I'm doing well. How about you?
Doing okay.
There's a jury trial in my courtroom, so I'm in branch 7 today.
I was wondering, that didn't look like the normal courtroom.
Yep.
Branch 7 doing the trial?
Yeah.
Okay.
And in this courtroom, the jury booth, the jury area hasn't been modified at all. So
I was gonna say, his courtroom is bigger than yours, I thought, where you'd almost expect that to be the better one to do it. But if it's, you know, an issue of not having the plexiglass yet.
yeah. Kevin, can you hear us?
I can now. I apologize. My computer crashed and froze first. I was able to get it back.
Kev?
I got it. Just got back
about the same
on.
time you did. All right. Sorry.
All right.
Okay.
Okay. We can call the case then. This is Brown County case number 20 CF 658, State of Wisconsin versus Stephen Arthur Schwarzenberger. The state is here by Assistant District Attorney Kevin Green. Attorney Brianna Zawada is here. Her client, Mr. Schwarzenberger, is appearing by phone. We're doing the hearing by video and phone conference because of a global, national, and local public health emergency requiring limited in-person appearances in the courtroom for everybody's health and safety. We are live streaming on YouTube. There is no one in the courtroom gallery. First, we do need an updated mailing address for Mr. Schwarzenberger. Attorney Zawada, do you have it, or should I ask your client? Oh, you're muted.
You can ask Mr. Schwarzenberger directly. Thank you.
Okay. Mr. Schwarzenberger, what is the best address to receive mail for you?
It is 11306 Old U. And that's just the old and then the letter U. Gillette, Wisconsin.
And the zip code?
54124.
Okay, got it. And then Attorney Zawada, what is the status here today? No, you're muted again.
Sorry. I'm still working on negotiating this case with the DA. I'd ask for one more date. I anticipate that it will resolve then. We would ask to schedule this by Zoom. Mr. Schwarzenberger believes he'll be able to appear by video next time.
How about Monday, March 8th at 1:30?
That's good for me. Does that work for you, Mr. Schwarzenberger?
Yes, that works for me.
Perfect.
Anything additional from the state?
I'm sorry, I missed the time on the 8th.
Monday, March 8th at 1:30.
Thank you. Nothing further.
Then bond continues. That's all for today. Thank you.
Thank you.
Yep, thank you.
And that's also the last hearing of the morning.
Thank you.